call the meeting of the St. John Plan Commission for January 7th to order. If we could all stand and do the Pledge of Allegiance. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please.
Mr. Burleson.
Here.
Ms. Cardona.
Here.
Mr. Gill.
Here.
Ms. Little.
Here.
Ms. Vucinic Woland.
Here.
Mr. Kennedy.
Here.
Mr. Eberly.
Here.
Mr. Kraus is absent. Attorney Decker.
Here.
And Mr. Panzik.
Here. All right, 6 members here. We have a quorum. Minutes, as you are all aware, you were probably not here on December 4th for the previous Plan Commission, nor was I. But in order to make these public record, we need to have them approved by this board. So I will need a motion and a second to approve the minutes for December 4th. And I would just turn to Paul and maybe Rick, and just to verify the information you saw in the minutes are accurate. You can make your motion contingent on that, going by the opinion or the fact of that Paul and Rick thinks they're accurate. And then we can get a motion, and then we can get a second, and then we'll do a approval.
Mr. President, I did review those, and from my perspective, they were in order, yes.
Okay.
Mr. President, I would concur. Everything appeared accurate and as it happened.
And don't call me Mr. President. All right, if I can get a motion, please.
I'll move that we approve the meeting minutes
I got,
contingent on Mr. Panzik and Mr. Eberly's recommendation that they're accurate.
I got a motion. Do I have a second?
I'll second that motion.
Second, all in favor?
Aye.
Opposed? Okay, motions, minutes pass. Now, election of officers, we have to appoint 3 positions, and then appointment of the recording secretary, which I'm going to almost defer to Margaret. But, so if we can have a motion for a president for the Plan Commission for this would be a 1-year term. I would imagine the president's a 1-year term. So if anyone has a recommendation for that position, we'll take it, and then we'll vote on it.
I have a motion for John Kennedy to be president.
Second that motion.
We have a motion, a second discussion. Does anybody else want to be president? I'm going to kill you guys. Well, you might regret this. All right, we have a motion and a second. If we can get a roll call vote for this one, please.
For
President, John Kennedy, and
as
President, yes.
Bob Burleson.
Yay.
Oh, man.
Yolanda Cardona.
Yay.
John Gill.
Yay.
Donna Little.
Yay.
Nancy Vucinic Woland.
Yay.
John Kennedy.
Yeah, yes, I'll go with the vote. All right, well, you might regret that. So we have a president now. As president, we will need to make a recommendation for a vice president. Is there a motion on the table for a vice president? Is there anyone that would like to be nominated for vice president?
I move that we nominate Bob Burleson for vice president.
We have a motion for Bob Burleson to be vice president. Do I have a second?
I'll second that.
We have a second. We will do roll call for this one as well. We have Bob Burleson nomination for vice president.
For Mr. Burleson, for vice president, Bob Burleson.
Yay.
Yolanda Cardona.
Yay.
John Gill.
Yay.
Donna Little.
Yay.
Nancy Vucinic Woland.
Yay.
John Kennedy.
Yay. Bob, congratulations.
Thank you.
Now we need an executive secretary, sorry.
Mr. President and members of the Plan Commission, when you make this nomination, please keep in mind that the executive secretary needs to be someone who is available to sign documents as they come in to the Plan Commission. Oftentimes, they are not brought to the Plan Commission in particular, Plan Commission meeting in particular. Plats of subdivision, for example, come in during regular business hours. So I would ask that that person be, let's say, a little more readily available for signing of documents as needed.
Do we have a motion? So, based on Rick's recommendation, it would be one of the municipal appointments, which I believe would be Donna or John. So I would need a recommendation for either one of those to do it. So
Whoever wants to.
I recommend Donna.
I have a motion. Do I have a second?
Second.
We have a second. Roll call, please. Motion and second for Executive Secretary for Donna.
Bob Burleson,
Yay.
Yolanda Cardona,
Yay.
John Gill,
Yay.
Donna Little,
Yay.
Nancy Vucinic Wooland, John Kennedy.
Yay.
And Nancy, were you the second on that? Or was that Yolanda?
I was.
I thought that was you. Thank you.
Now, the appointment of the recording secretary is one that takes the minutes and notes for the appointment. So usually this would be Margaret would do that. So if I have a motion and a second for that, then we'll just do we won't do roll call for that one. So do I have a motion for Margaret to be the recording secretary?
I move that we nominate Margaret as the recording secretary.
I got a motion, second?
Second.
We'll just do all in favor?
Aye.
Opposed, nay, that carries. Now we have an appointment to the Plan Commission. This is a BZA appointment to the Plan Commission. I am already on the BZA. I don't know if anyone has any time constraints or if there's anybody that is interested in serving on the BZA that would like to put their name up for nomination. We will hear that, and then the board will need to make a motion. I believe that is a one-year term to the BZA from the Plan Commission, so if there's anybody interested or if there's a nomination for the Plan Commission here. As president, I cannot make a motion, so just so you guys know.
I'll make a motion to nominate Nancy. Busick, sorry, for the, appointment for the Plan Commission member to the, BZA.
We have appointment of Nancy to the
I'll
BZA. Do I have a
second that
second?
motion.
I have a second. Roll call vote for that one, please.
Bob Burleson,
Yay.
Yolanda Cardona,
Yay.
John Gill,
Yay.
Donna Little,
Yay.
Nancy Vucinic Wooland, John Kennedy.
Yay. Congratulations. I'll see you in 2 weeks. Going on to the next point of view, public hearing, we have none, so that's good. Point number 7, old new business, we have some Plan Commission training. At this point, Rick, I'll turn it over to you.
Thank you, Mr. President. Aptly so at this point. I wanted to let you know that you have some documents there in front of your various seats. You have a hard copy of the zoning ordinance, the subdivision control ordinance, and the comprehensive plan. Now, John Kennedy, you and John Gill do not have the zoning ordinance and subdivision control ordinance because I wasn't certain of whether you still had your original copies.
I still do.
These are available electronically as well, so if you prefer not to have a hard copy, you can leave yours behind and simply access it online when you want to do that. But I did make hard copies for you and also included a copy for Mr. Adam Decker. Now, Adam has not had a chance, I don't think, to introduce himself formally to the Plan Commission. I think he's met each of you before the meeting, but Adam, if you would just take a moment and.
Thanks, Rick. Good evening, everyone. My name is Adam Decker. I'm an attorney. My office is located in Crown Point. I've been practicing law now for 26 years. I am married to my wife, Becky, and I have 3 sons, 2 of whom are in college and 1 who just graduated from college. My areas of practice include real estate. I have previously served in various capacities for different towns, for plan commissions, BZA, water boards, stormwater boards, and similar municipal capacity. And I very much look forward to working with you throughout the course of each of your terms, but also to present some information tonight and hopefully provide some useful training regarding your roles as plan commissioners. So thank you.
Thank you, Adam.
And Rick, before you begin, that's a great idea, and I apologize to the board that I didn't think of this earlier. Can we do an introduction
Sure.
to the general public as well? Bob, and, I mean, Rick, you can go, start next, and
Okay.
give a little brief introduction to the Plan Commission, and then the Plan Commission, if you could just give a little background, because from your background and your qualification, the town council thought your opinion matters. So it might be good just to give a little opinion, brief history about yourself. So,
Certainly.
Rick.
My name is Rick Eberly. I'm the Director of Building and Planning here for St. John. Actually began my municipal career with the town of St. John in 1989. Spent 3 years here. Then I was recruited by the town of Dyer to come and work for them in the same capacity. And I worked for Dyer for 24 years in various capacities as a zoning administrator, redevelopment director, and ultimately town administrator before retiring from the town of Dyer in 2016 and coming back to work here in St. John in late 2016. Just celebrated my 3rd anniversary, second time around with St. John. I have had the privilege and honor of working with Adam Decker when I was with the town of Dyer. He was our stormwater board engineer. Attorney. He is an engineer, by the way, also. I don't know if he mentioned that, but he's an engineer as well as an attorney. But he was our stormwater board attorney for a number of years, so we've had a chance to work together and enjoyed that. But I'm glad to be back here in St. John and looking forward to working with the 6 of you and our 7th member whenever we get that person.
My name's Bob Burleson. Been a resident of St. John for about 18 years. I'm married to my wife Teresa for 28 years. We have 5 children, and I've been working for engineering firms for the last 25 years, 24 years. Mostly municipal work, sewers, designing sewers, water mains, being at the resident engineer on site. Worked for Village of Mokina for 4 years, just mainly overseeing all their infrastructure going in. So happy to be on the board.
I'm John Gill. I'm married to my wife Stephanie. We have 1 son. I started working for the town in 2006 as part-time summer help while going to college at Purdue Cal. And over time, the town offered me a full-time job, which I accepted and kept going to school at night. And in 2009, when I graduated, there wasn't a whole lot of jobs out there, so I stuck with the town and eventually became the building commissioner where I am now. And along the way, I joined the volunteer fire department, which I've been on for 13 years. And look forward to serving on the board and giving my opinion on what would be best for the town's future growth.
It's hard to follow you. John Kennedy, resident of St. John for 17 years now, wife and 2 kids. Been with an engineering architectural firm for the last 15 years. Worked for the state of Indiana for 2 and the Northwest Indiana Forum, a regional economic development group, for about 12 years prior to that. Born and raised in Lake County. Was fortunate enough to move close to my parents here in St. John, and enjoyed it ever since. Tried to teach my kids the responsibility of not only community service specific duty. That I appreciate the town council giving me another opportunity to not only put my words, but to put them into action, to show my kids that they have a responsibility to the community in which they live in. So I appreciate the next 4 years to do that, and look forward to working with the town council to make this place a better community. So thank you.
I'm Yolanda Cardona. I have lived in St. John for about 1.5 years. My husband and I moved to St. John to look for a nice community to raise our children. And we felt that St. John was the place to do that. So we're very happy to be here. My husband's a longtime police officer, and I am an attorney. I primarily focus in trial practice here in Crown Point, Indiana. I'm licensed in Indiana to practice law. And I really look forward to working with all of you, the 7 members of the Planning Commission, as well as the attorney and everybody else here, and with the residents, most importantly, to make sure that St. John moves in the right direction. Thank you.
Hi, my name is Nancy Busenick-Wolin. I've lived in St. John for approximately 17 years. I have 5 children. My husband Chuck. A lot of my family and children live in St. John, so I care about what happens to St. John. And I thought, like John says, I talk to my children and my 9 grandchildren about civic duty, and if you don't like something, you need to do something about it. You need to get involved. You need to share some of your time. So I appreciate the board doing interviews. My experience is, I worked at AT&T for many years in the engineering department. I was the area manager of design. What that basically means, if there's a new target going in or a new subdivision, we design the cable layouts for that. I worked with Commonwealth Edison as their liaison from AT&T, so I did pole work. I've done road jobs, conduit placement, rehabs, so I've kind of done the gamut of utility work for AT&T. So I'm happy to be on this board, and I'm anxious to work with the members and do something for the town of St. John, and most importantly, the residents.
Hi, my name is Donna Little. I've been a resident of St. John for 15 years. I'm married to my husband Nick for 22 years. We have 3 children. I've worked for the town for the last 4 years. I'm the billing supervisor, and I also work very close with the Public Works Department, Water Department specifically. I have worked in banking, and I've also worked for a developer, a company that developed attached housing for seniors in Illinois. So I'm very happy to be on this board and serve the community, serve the residents of St. John, and keep our town moving forward.
Paul, you want to say anything? Paul is our town council liaison.
Good evening, everyone. First, I'd just like to thank you all for stepping up and serving. It's really appreciated. I'm sure our residents appreciate it. It's not an easy job, and you will surely be a target at times, but I know you're in it for all the right reasons, and I think you'll enjoy it in the end. You make a little bit of a difference, and it's a good thing. So I think everyone knows me already, but for those that don't, Paul Panzik, served on this plan commission, served on the BZA for 6 years, the last 2 as a chairman. Been in St. John 10 years. Previous to that, lived in Cherville and served on their plan commission for 4 years with some good people there as well. So now I've stepped back from the plan commission to allow more residents to be involved, and I will be your town council liaison. Thank you.
Sorry for the interruption, Rick, but I thought that was a great idea when you introduced the attorney. So we'll go on to the plan commission training, and I'll turn it over to you.
Okay, we have a series of slides here that we're going to go through. Please feel free to stop me and ask questions at any point during the training session. Adam will also join me in explaining some of these slides and some of the information that you're going to get. I also neglected to tell you that I also provided you with a copy of the rules and regulations for the Plan Commission. These are put in place to instruct you on how we conduct our meetings and our business, and what it is that we are here to do, what petitioners have to do when they come before us. And it's an important document that I know Bob and John, both Johns, I think, were on the Plan Commission when we updated this in 2017. They hadn't been updated in a while, so they needed some revision. Paul was on that Plan Commission that did that as well, so we're happy to get those rules and regulations updated. With that, I'll go into the slides themselves, and we're going to give you a background on what it is that we're here to do. But I start by letting you know that I don't cite Indiana code specifically. But I do point out that if you should have any desire to look at the code that regulates what it is plan commissions do, it can be found at Indiana Code 367-4-100 through 1699. And that is, just so you understand what those numbers mean, it's Title 36, Article 7, Chapter 4, Sections 100 through that Section 1699, and the acronym is TAX. title, article, chapter, section. So you can find this information online. Here are the various sections. Section 100 is applicability, and you can see the rest. I don't need to read those, but the ones we concentrate on the most are the zoning ordinance and the subdivision control ordinance. As you'll learn a little later, you have a lot to do with the adoption of a comprehensive plan. You put that together for the town council, who ultimately would adopt it. Our comprehensive plan was also most recently updated in 2017. It was a process that the town had been going through in 2016, and the adoption actually happened in 2017. So the comp plan was basically updated by the time I got here. But it's typical to do a revision to comprehensive plans every 5 years or so. That is at a community's discretion, but before a community can adopt a zoning ordinance, it must adopt a comprehensive plan. Here's some of the other sections. The 900 section of the Indiana Code has to do with Board of Zoning Appeals particularly. We don't have anything to do with section 1200, the township joinder, but we do deal with development / site plans, the 1400 series, and PUDs as well. So, but again, just so you understand a little bit about where the law comes from that we follow as a plan commission. There are several types of plan commissions in Indiana: a metropolitan plan commission and an area plan commission, as well as an advisory plan commission. We are an advisory plan commission. An area plan commission, Adam, generally speaking, is a county plan commission. Metropolitan is a city. Is it
Well,
city and combination, city, county?
It's a little bit more specific than that, too. Metropolitan typically would involve the Marion County or the city of Indianapolis, so.
Right. But we are an advisory plan commission, so if you're ever looking at that law, and you see a section that says area plan commission or metro, they shorten it to metro plan commission. You don't need to be concerned about that. We're advisory. As such, our plan commission consists of 7 members, as we've talked about. Those members are appointed as follows. The town council executive appoints the 4 citizen members. Of those 4 citizen members, no more than 2 can be of the same political party. So you can have 2 Democrats, 2 Republicans, you can have 2 Republicans, a Democrat, and an independent. Whatever the mix is, you just can't have more than 2 that are of the same political party among your citizen members. The 3 members that must be either elected, appointed, or employees of the town, their political affiliation is irrelevant. The town of St. John has chosen to make those 3 positions an annual appointment. They can be a 4-year appointment if the town were to choose to do that, but historically the town has made those 3 appointments on an annual basis. The terms of the 4 citizen members are for a period of 4 years, and like I just said, the terms of the 3 municipal members can be 4 years, but by practice, we've made them 1-year appointments. We conducted this at this meeting here. The first meeting of each new year, the commission has to elect a president, vice president, and can elect an executive secretary, and we choose to do that. And then appoint a recording secretary. The president and the executive secretary sign the subdivision plats when they are approved. And if the president was not at a meeting or is unable to sign, the vice president can sign in his or her absence. These are the duties of a plan commission. As I mentioned earlier, you prepare the comprehensive plan. You can prepare amendments to the comprehensive plan. You can prepare and amend the zoning ordinance, the subdivision control ordinance. You approve or deny plats of subdivision. You assign addresses to plats of subdivision. Typically, that's done by the developer's engineer, and we just check that. That's a checklist item that's reviewed between Ken Kraus, our town engineer, and myself, we just make sure that they're in the correct order. And in St. John, the north and west sides of the street are even numbered addresses. South and east are odd numbered addresses. So we check on those things, make sure that those are in the proper order and that the sequencing is correct. John, north to south, what's our?
Larger to the south and larger to the west.
Right, right. And our, we have 4 and 5 digit address numbers. We don't
Correct.
have any 3 digits, right?
No.
All
no
4 and
three-digit.
5.
They start at about 7,300 in Tiburon, and they get up to
144,
14,000
14,
out by Bramblewood and Edgewood.
right, right.
And then same thing, it starts at 82nd, 83rd, 8,200, and goes down to
8,200 at the north and
at
goes
the
down
north,
to.
and then
Right.
11,000 in the south.
Our town boundaries, by the way, are huge, really. We'll likely wind up the largest of the 3 tri-towns, Dyer, St. John, and Sherrville. Population-wise, I think we'll find in the 2020 census that we've passed Dyer. We haven't caught Sherrville yet, but given our town boundaries and our utility district, we have a lot of room for growth. We can go as far south as 125th Avenue. We can go over to the state line on the west, and then the east boundary and the north boundary, as John knows, are very irregular because of our, some of it's unincorporated. We have some land between us and Sherrville, but we don't quite touch Sherrville yet. But
Right.
it's a pretty irregular boundary, but we have a lot of room for growth, and that's one of the reasons why we're experiencing growth. So you make recommendations to the town council on rezoning requests, and you make recommendations to the town council on impact fees. Those items that you deal with that require public hearings are the comprehensive plan, either an adoption or an amendment, the zoning ordinance, same thing, adoption or amendment, adoption of a subdivision control ordinance or amendment to that, and then primary plats of subdivision are also subject to public hearings. Public hearings differ from public meetings by way of the requirements for a public hearing. There's public notice that has to be presented to interested parties. We go a little above and beyond what the state law calls for. We require a 15-day notice currently for a public hearing. And by that I mean there's notices that have to be placed in 2 newspapers, the Times and the Post-Tribune. There's letters that have to go out to adjacent property owners within 300 feet of a given subject parcel. Those have to be, the notices have to be published in the paper at least 15 days in advance, and the letters have to be postmarked at least 15 days in advance. In addition to that, you have to put a sign on your property notifying the public of your appearance at a given public hearing. That has to be posted on the property at least 15 days prior to the public hearing, and that has to remain on the property for that entire 15 days at minimum. Again, the 15-day rule is our rule. The state statute calls for a 10-day notice, and the state statute does not require 2 publications. It only requires 1. It does not require a sign to be posted on the property. That's our regulation. Some communities do that, some don't. And then the letters, the notice to adjacent property owners, we use a 300-foot search list. Some communities use immediately adjacent, some might use 500 feet. That is up to the individual municipality to determine that, and that's what we have in our rules and regulations. That outlines what a petitioner has to do. But some of that is statutory, some of that is just local regulation. I'm sorry, skipped over. The items that you deal with that don't require a public hearing are, among others, site plan review and approval and a secondary plat of subdivision. Secondary plat of subdivision is also known as the final plat of subdivision, and so long as it conforms substantially with the primary plat that you've already conducted a public hearing on, it's what's called a ministerial approval. And Adam, if you don't mind expounding on that a bit for secondary plat ministerial approvals?
Rick, so in the functions of the Plan Commission, there's sometimes references made to discretionary approval versus ministerial approval. And so ministerial generally refers to the process of reviewing, in this case, a secondary plat of subdivision, which has been previously reviewed and approved by the Plan Commission. And as Rick indicated, if it substantially conforms with the primary plat, then the ministerial function of the Plan Commission to approve secondary approval really takes out any discretion on the part of the Plan Commissioners to, in that case, deny a secondary approval.
Thank you. This is another important point. When you do conduct a public meeting, whether it's a general public comment or a part of a comment that's part of a public hearing, the person who approaches, they have to approach the podium. They give their name and address for the record. Their comments are to be made to you folks, not to the petitioner, not questioning the petitioner, not having discussion with someone else in the audience. The questions are directed at you folks. Or their comments. And as the last sentence says, they're all persons, that means us here as well as those in the audience should conduct themselves in a respectful and courteous manner for the best operation of the conduct of the meeting. But again, the important point there is that they need to address their questions or comments to you as the Plan Commission. And here it's, and some of the members here have heard me explain to both at Plan Commission and BZA level that oftentimes we'll get members of the audience who don't understand why we're even entertaining a request that we get. And what they need to understand, what we need to make them understand is that we don't have any choice. A landowner, a petitioner has a right to come in here and ask for whatever they want. If I sometimes use an exaggerated example, but let's say in the middle of a single-family residential subdivision, somebody comes in and wants to put a hotel on a lot right in the middle of that subdivision. They have a right to ask. The people who get notice of the meeting and come to the meeting, they're already upset that they're even having to come out for a meeting like that such a request should even be entertained, but we don't, I think it's proper to say, Adam, we don't have legal position to tell someone they cannot make a request of either you or the Board of Zoning Appeals, if for that matter.
I would say that's generally correct, Rick. I mean, I think part of that process, anybody who comes before the Plan Commission who's proposing something for serious consideration, hopefully will have done their homework, their due diligence, will have perhaps met with Rick to discuss what some of these requirements for whatever the specific request is being made. But at the end of the day, I tell this to clients all the time, anybody can sue anybody for any reason. That doesn't mean that it's a meritorious claim or lawsuit or that it'll get much further than the filing with the court, so.
Mm-hmm. So you'll see oftentimes, especially if something is controversial, either the president of the board or I will just try to let the folks in the audience know that we're here to listen to this request because we're required to do so. Actions taken at your meetings are only official if they receive a vote of the majority of the Plan Commission membership. So that's important. If there's only 5 of you here and 3 of you vote for something, that's not enough. There has to be at least 4 of you voting in the same way in order to approve or deny a request. So even with our being a 6-member board so far, and most of last year we were a 6-member board, it still took 4 votes because the membership is 7 by statute. I mentioned about the Plan Commission rules and regulations that they were adopted in August of 2017, and they regulate how we conduct our business. The process of a public hearing goes like this. The petitioner approaches the podium and makes its presentation of its plan to the Plan Commission, and it enters into a discussion with you folks. Once the Plan Commission members have had a chance to discuss this with the petitioner and ask any questions that they have, the meeting is then opened to the general public. Now, we do two things, and Paul, I didn't get a chance to check that sheet. Did anybody sign in on that comment sheet there? No, okay. What I do is I put out two comment sheets. Well, it can be more than that depending on the number of petitioners, but if we have a petitioner here for a public hearing, there's a sheet that people can sign in on over there indicating that they want to speak when this topic comes up. So we'll take anyone who has signed in first, call their name, give them a chance to approach the podium and make their comments. Once the list is exhausted, we'll still ask if there was anyone who didn't get a chance to sign the list that wants to speak on a given topic. And we'll do that for each item that's under the public hearing. At the end of the meeting, there's general public comment, and that is on your agenda. Item number 8 on your agenda is public comment. So that can be about any topic that someone wants to discuss. The other one is specific to the public hearing topic. But typically, once people have had a chance to make their comments, then the board president will close the public hearing, bring the matter back up to the commission, and you'll discuss it again. The petitioner has a chance to address any of the public comments that were made, and you have another chance to continue the discussion with that petitioner. The public hearings are not always closed in that matter. They can be left open to be discussed at a future date, particularly if there are questions by the Plan Commission that the petitioner cannot satisfy. You can certainly continue either the public hearing or your decision to a future meeting. You can close the public hearing at this meeting, for example, but continue the decision on it to a future meeting, or you can keep the public hearing open and continue it to a future meeting. I know, Paul, that there has been at least one occasion where we have reopened a public hearing at a later date after having closed it. And Adam, you and I hadn't had a chance to discuss that, but is there any legal issue with reopening a public hearing once it's closed?
No, I don't believe there's any issue with reopening a public hearing once
Okay,
it's
so that's at
closed.
the discretion of the Plan Commission?
That's correct.
Okay, because we have done that. Particularly when new information surfaces regarding a petition, it's wise to reopen the public hearing. The continued public hearings or continued meetings don't have to be re-advertised, however. It's enough to state at this meeting, this is continued to next month, that people are determined to have gotten notice that the meeting is being continued. Where rezoning requests are concerned, the Plan Commission conducts the public hearing on the matter and can take one of 3 actions. It can make a favorable recommendation, an unfavorable recommendation, or no recommendation to the town council. The council then makes the final decision on a rezoning matter. You'll see in a moment that that doesn't apply to platting. Subdivision platting is exclusively your jurisdiction.
And just for clarification, the town council does not have to follow our recommendation.
Good point, good point. They do not. They can agree with it, they can overturn it, and make their own decision.
And we have done in the past, currently we have 6 members, if it has been a 3-3 vote, we just make it a no recommendation to the town council.
Correct, and they make the final decision. They also have, and you'll see on a future slide, that the council must act on your recommendation within a certain period of time. I'm sorry, back up to this 1 second. Subdivision platting is concerned, I mentioned that a minute ago. The Plan Commission conducts the public hearing on the primary plat request and the Plan Commission has exclusive authority over the approval or denial of a plat of subdivision. And once again, if you're not comfortable that you have enough information at the meeting that it's being presented at, you certainly have the right to continue the matter to a future meeting to get more information, and we've done that any number of times over the 3 years that I've been here. Site plan requests are reviewed and acted upon at public meetings, but they're not subject to the public hearing process. They don't have to send notices out, send letters to adjacent property owners, things like that. So that would be, as an example, that would be, let's say Target, which is already a platted subdivision and an approved use, wants to do an addition to their property. That requires site plan approval. Probably, depends on the extent of the addition, or, for example, John, Target did an interior remodel that was not subject, interior remodeling projects are not subject to site plan approval.
Right.
And additions of certain percentages to buildings are not subject to site plan approval either, and you'll see that a little further on here. But in any case, site plans, you make your decisions at a public meeting, but it's not a public hearing. And when I say public meeting, you'll have a study session later this month. That's a public meeting in terms of the fact that it's open to the public, but it's not a meeting at which you can make decisions. So when we refer to public meetings or regular meetings, when we refer to those, use that terminology, we're talking about meetings at which you can take actions. And it's your first meeting, first Wednesday of the month, that is your official meeting or regular meeting. Your study session is the third Wednesday of the month, both at 7 p.m. If you consider changes to the subdivision control ordinance or zoning ordinance, you must ultimately conduct a public hearing on those changes, because you're making an ordinance. You're recommending a change to an ordinance, so that requires public hearing. You make a recommendation to those changes to the town council, and then the council decides whether or not to adopt the changes. This is another reason why it's important to have Paul as a liaison to the town council, because he can take the information that he's heard at this level and relay it to them. I can do that as well, but Paul's in a position to let his fellow council persons know what's coming their way in the way of actions that they would have to take at future meetings. Going to walk through some scenarios that you may deal with, so you get a feel for how you can how you should respond to some of those. This refers to the slide, I think slide 16 that I had. It just says, be aware that a person has a right to request whatever he or she desires, and that often causes distress to our residents because they don't understand in some cases why we're even entertaining a given request. And the fact of the matter is we can't refuse to entertain the request. And oftentimes, folks come here thinking that you've already approved something when you haven't even heard it yet. And that just, as Bob's shaking his head because he knows he's been there, done that. And people will think that you're going to approve it just because you've allowed it to be here in the first place, and that's just not the case. So in this first scenario, Mary Smith wants to rezone 20 acres of land on the south side of 93rd Avenue east of Klein Avenue from open space, OS is open space, to R2 single-family residential. She wants to get a feel for whether this will be acceptable by members of the Plan Commission. So she contacts each of you privately to discuss the matter. Can you legally discuss this with her outside of a Plan Commission meeting? The answer to that is yes. In Indiana, there are many states that don't allow that. That's called ex parte communications, and you cannot do that if you're a member of the Board of Zoning Appeals. So Nancy, I believe you've taken that on, and John is on that. So John understands that if somebody approaches you as a member of a Board of Zoning Appeals about a matter, you can't discuss that outside of a meeting with them. But as a Plan Commissioner, you can. It's frowned upon, but I've made this. I mean, we're a growing community. We're a lot bigger than we were when I was here 30 years ago, but we're still a relatively small town at heart. You run into your friends and neighbors at the grocery store, and they're asking you, hey, what's going on? Why are you doing this? What's coming before you? You can discuss that as a Plan Commission member. but again, it's frowned upon, but allowed in Indiana. Okay, so she ultimately decides to attend a plan commission meeting in an effort to follow through with the rezoning request. Does she have to own the land in order to make the request? And the answer to that is no, but she does have to have the approval of the landowner to make a presentation and a request of the town, and that's generally done in the form of a power of attorney letter, Adam.
Yeah, typically, yes, that's correct, Rick. Oftentimes we'll find that a proposed developer may have a plan for a proposed development, and before they decide to move forward, which the steps would include the purchase of the property, even before they purchase the property, they may want to seek approval of certain land uses for the property. That might involve zoning, and it may even involve a plat of subdivision, a proposed plat. And so typically in that case, the owner would have to give the developer, or in this case, the petitioner, the authority pursuant to a power of attorney, which makes the developer the attorney in fact on behalf of the owner. And that's something that the town would require to be provided in written form, an actual document that shows that the developer or the petitioner before the plan commission has that authority and the permission of the owner to move forward with that proposal. And so in that case, the developer, if those approvals are granted, that's a condition to the purchase agreement, and then they would proceed to purchase the property if they're satisfied with the approvals that have been made by the town. So.
And it's very common in those situations where a purchase of land will be contingent upon the interested party getting the approvals that they're seeking, whether it's a rezoning or a platting of subdivision or whatever it might be. But that purchase of the land will be contingent upon the approvals by the community.
And Rick, just to add to that, as an attorney can actually be appointed as an attorney, in fact, pursuant to a power of attorney. So oftentimes attorneys will represent developers before the Plan Commission and the BZA, and they will be given that authority pursuant to an executed power of attorney document. So that's also sometimes done in that capacity.
That's correct. Oftentimes, we'll see engineers appear on behalf of the owner. Almost every time, the owner of the property is also in attendance with the engineer. So we know that the engineer has the authority to make the presentation for the property owner. But yes, it's typically an attorney or an engineer that's making that presentation on behalf of the petitioner. What town document do you want to consult prior to making your decision on the rezoning request? And I don't expect you to know the answers to these, so I'll just jump to the answer. And that is the comprehensive plan. The comprehensive plan lays out how the town feels that the community should develop. It doesn't zone property R1, R2, or C1, C2. It lays it out in residential, commercial, and industrial. And from there, then you will get if you get a rezoning request for a piece of property that in the comprehensive plan is shown to be residential and somebody wants to rezone it to industrial, that doesn't mean you can't do it. The comp plan is just one of 5 factors to be considered in a rezoning request. But you'll want to look at that and say, okay, this is supposed to be residential. I don't think industrial is the right use here. Or they might ask for commercial, and then you've got to decide whether you think, based on the other factors relative to a rezoning, that the rezoning request is proper. But you'll want to become familiar with the comprehensive plan and again, but don't confuse it with the zoning ordinance, because the zoning ordinance breaks down our land uses into specific districts. R1, R2, R3 are residential, obviously. C1, C2, C3, those are commercial. That breaks it down specifically, but the comprehensive plan just generically says this should be residential, this should be commercial, this should be industrial. And then you would work on a rezoning from there. Who makes the final decision on a rezoning request? The Plan Commission or Town Council? We touched on this a few minutes ago. That is a recommendation you make to the Town Council, but the council makes the final decision on a rezoning request. There's the answer. Now, I mentioned earlier the time frame. The Town Council has to act on the Plan Commission's recommendation within 90 days of the certification of that rezoning request. If they don't, then the action is taken based on the Plan Commission's recommendation. So if you make an unfavorable recommendation on a rezoning and it goes to the council and they don't act on it within 90 days, it is denied. If you make a favorable recommendation, it is approved if they don't take their own action on it. If it's a no recommendation, I don't have the answer to that one.
Well, if there's no recommendation, well, I want to confirm that, but I would think in that instance that the proposal would not be approved or would not go into effect. But I'll confirm that.
Okay.
That very seldom would occur. There would be
Yeah.
no recommendation by the Plan Commission, and the council would not act within 90 days.
In the 30 years I've been in this business, I've seen it happen one time. So it shouldn't happen. These are the 5 factors I mentioned earlier, or I mentioned earlier that there are 5 factors that the Plan Commission is required to consider in acting upon a rezoning request. Now, when that's before you as Plan Commission members, I provide you with those. Those are statutory criteria, 5 criteria by state law that you have to consider in a rezoning request. And we have the form for that I put in front of you. And each one of you can look at that during the meeting and decide whether you think they do or don't meet those or satisfy those 5 factors. They don't have to be all yeses or all nos. But you use those factors to approve or make your recommendation one way or the other on the rezoning request. Now, here I say of the factors identified below indicate by yes or no whether the given factor is one of the statutory criteria to be considered. And you'd be able to read the list and probably pick out the ones that are most likely those, and I'll show you those. But for example, too many trees would have to be removed if the land were rezoned. That is not a statutory criteria by which you judge a rezoning. The comprehensive plan is. Whether wildlife would be displaced or not is not one of those. So I'll just go to the next slide and show you that the ones that are highlighted here in orange are the 5 statutory criteria. But you get an idea. You'll hear all the arguments against a rezoning, and a lot of you have been at public hearings, and you know that typically the folks that come out to public hearings are folks that are upset about the request. It's not typical to have folks in the audience that are there to support it. But these are the criteria by which you need to judge each rezoning request. Scenario number 2, John Doe is seeking primary plat approval for a duplex subdivision on land that is currently zoned for duplex use, R3. Assuming he meets all of the criteria for subdivision development as prescribed by the subdivision control ordinance and the zoning ordinance, can the approval be denied? Typically, that answer is no. If it meets all of the criteria, and we're talking about platting approval. Again, remember, this is not zoning here, this is plat. If the plat meets the conditions of your ordinance, it's typically a ministerial action that has to be approved. Who makes the final decision on a primary and secondary plat of subdivision? The town council or the plan commission? As I mentioned earlier, that is the exclusive province of the plan commission. Is a public hearing required in order to consider acting on a secondary plat? The answer to that is no. It's only required for the primary plat. If the secondary plat does not differ in any way from the primary plat, can it be denied? Again, we touched on that earlier. No. If there's no difference between the two plats, then the secondary plat is a ministerial approval, cannot be denied unless the primary plat is expired. And we'll go into that in a minute. Primary plats can expire. And here we go. How long is a primary plat approval effective for? By our rules and regulations, it's good for 12 months initially. Can the primary plat approval period be extended? The answer to that is yes. But it should be noted that in a multi-phase development, if you've got a subdivision that's, let's say, 5 phases, and they get a primary plat approval on the entire layout, and they come in within the first year period and they get a secondary plat of one of the phases, that automatically extends the primary plat on the remainder of the property by another year.
And usually we extended those for, what, about 6 months?
Well, that's the distinction I'm gonna make next, John, is if, first of all, is there a limit to the number of months that a primary plat can be extended when a developer makes a request for an extension? And that's where John's getting at, and the answer to that is yes, up to 6 months at a time. So if they come in and they need an extension of the primary plat, they can only ask for a 6-month extension max, anything from 1 to 6 months. And again, that's our local rule. That, in the town of Dyer, for example, that's up to a year. And so it's up to the municipality how long a length of time that they want to grant for each extension. In St. John, we limit that to 6 months. Is there a limit to the number of times that a primary plat can be extended? The answer to that is no. Neither by statute nor by local rule do we limit the number of times someone can seek that extension. But it's important to note that, as I said a minute ago, if you come in for secondary plat approval of a given phase of a project, then that automatically extends that primary plat by 12 months. If a developer's simply coming in to seek an extension of the primary plat, they can only get a 6-month extension with each request.
I think a good example of that would be the Gates, where I think it was 2005 or so, they got, we'll just say, to sum it up, they got primary plat approval for everything between Parrish, Klein, 231 and Joliet, or 101st, whichever you call it. And every year they've come with a little secondary plat here, there. And so that's still been rolling on since
Right.
around 2005, 2006.
And there's currently 20 pods within that geographic area that John just described, and now they're looking to bring in additional pods outside of that. But, so, yeah, every time they get a new secondary plat, extends the primary by another year, so. Scenario number 3, a commercial building owner wants to add a 2,000 square foot addition to her existing 10,000 square foot building. Does she have to apply for site plan approval? You'd have to know what our ordinance calls for, but it needs a 25% 25% addition to a building requires site plan approval. So in this case, this would be a 20% addition, and would not automatically need site plan approval unless, if the addition does not result in the need for an increase in parking spaces, then she does not need to apply for site plan approval. Otherwise, she would. Does she have to comply with the outdoor lighting ordinance requirements? Only if she's adding or changing outdoor light fixtures. Again, what we're getting into here is our rules and regulations. This is not statutory. Is site plan action conducted as a public hearing? And the answer to that was no. It occurs at a public meeting, but it is not a public hearing. Does she have to comply with the landscape regulations? Answer to that, only if a new site plan is required. Want to take a moment to say that traditionally, we have not allowed public comment at all at study sessions. That's been a practice. It's not a rule or regulation, and it's not a statutory, it's not governed statutorily. So if this plan commission decides it wants to allow citizens to make comments or ask questions at study sessions, that would just be a change of philosophy. You could certainly opt to do that. With site plans, again, that's not a public hearing either, so typically you don't allow comments at the site plan phase, but again, there's a catch-all at the end of the regular meetings for public comments, and under that section, people can bring up comments about whatever they'd like. So something to think about going forward, and I don't know, Paul, if the town council has any thoughts about that, any directives that would like to advise the plan commission on relative to public comment at other than public hearings?
That'll be up to the plan commission to make that decision, and specifically the plan commission president. But I think as a council, speaking on behalf, I believe what everybody feels is the more involvement, the better. So if you see a lot of residents out there scratching their heads, wondering what's taking place in a study session, it never hurts to open up and entertain a few questions and perhaps have a little exchange and send everyone home with a better feeling or grasp of what's happening. So, and I've done that. John is familiar that I've done that at BZA meetings where I'll open up public comment at extra time, even if I have to, just to make sure the air is completely cleared, everyone's on the same page. So
Yeah, and great comments, Paul. And I echo those sentiments, because folks have taken time out of their busy schedules to come here for an evening, and to me, we owe it to them to give as much information to them as we can. And as Yolanda knows, sometimes for multiple meetings, folks have come out, and we just need to provide as much information for them as we can. It's frustrating, I'm certain, for people to sit out here that they don't understand what it is we do. That's not a knock against any of them. That's not what they do.
Right.
And it can have a whole different appearance. I hope that doesn't from the audience than it has up here, and we need to be sensitive to that. I'm all for trying to give folks as much information as we can, so they go away. So when they go away, they understand whatever the decision might be or whatever the issues might be. Whether they agree with a decision or not is another thing, but at least we need to do the best job we can in helping them to understand what it is that the issues are. Scenario number 4, Jane Doe is proposing to build a small hotel on 5 acres of land immediately north of Aspen Cafe. I think everybody knows where that is. What is the first question you should ask yourself? And that is the property zoned for that use? In order to determine that, you'd have to look at the zoning map that we have available. And assuming the parcel is zoned for commercial use, what document would you consult to see if the hotel is allowed in that commercial zoning district? That is the zoning ordinance. That's the largest document that you have there. Specifically, Chapter 3E, Schedule of Uses, lists, generally speaking, the uses that are allowed in each of the zoning districts. It can't list everything. But if it lists a hotel, then a motel is approved, for example. So there are some things that are very specific uses that if it's not in the zoning ordinance, it's going to take a rezoning or a BZA action to allow. But there are other things that are just retail uses, for example, are generally allowed in C2. So any retail use is allowed there. So you'll see when you look at Chapter 3E, Schedule of Uses, it's not going to list everything, but it tries to cover the bases there. During the public hearing for the platting of a one-lot subdivision, I should have said, where this hotel is going to be, several remonstrators from nearby subdivisions indicate that they do not want a hotel near them. Is this a factor that you can consider in making your decision relative to the plat of subdivision? And that answer is no, because you are just considering the platting of the property at that point. The use of it is not what your public hearing is about in that case. Fifth scenario, Jennifer Jones is seeking to rezone a parcel from open space to C3. The parcel is identified on the future land use map in the comprehensive plan as being commercial. Are you obligated to approve her request? And the answer is no, because she's asking for a specific zoning to C3, and you may feel that that's, by the way, C3 is our most all-inclusive zoning district. C1 is the most restrictive, and C2 is in the middle. You might feel that the list of uses allowed in C3, because this is what you have to consider is again, first of all, the comp plan is simply a guide for the development. It's one of 5 statutory factors to be considered. Second, it just identifies the land as potential commercial and doesn't presume to specifically zone it. You might look at the list in C3 and think, well, this is awfully close to small neighborhoods, and C3, the list of uses in C3 are just not appropriate for this area. Be more appropriate to do C1 or C2. So you're not obligated, just because the comp plan identifies it as being commercial, to zone it C3. Nor are you obligated to zone something R3 a duplex, multifamily residential, simply because the comp plan shows it as being residential. You might think single family, R1 or R2 is the more appropriate choice there. So you're not obligated to make that decision in favor of the petitioner. Before the Planning Commission makes its recommendation on that matter, you want to know what users she plans to put on the property. This is a spec building, so she has no one in particular in mind for the property. Planning Commission makes an unfavorable recommendation citing a lack of information regarding the end users. Is this a defensible decision? And I'll ask Adam to perhaps expound on this in a moment, but I believe it's a legally defensible position. But before if you have a proposal like that before you, where a developer truly doesn't know what the uses are going to be in that building and they're asking for C3, you need to be familiar with the list of allowable uses in the C3 zoning district so that you can get comfortable with making your recommendation, recommendation on that rezoning request. Because just because it's an acceptable C3 use that you think is fine now doesn't mean that it always will be. If you've zoned it C3, then any of the C3 uses can occupy that space. So you have to be familiar with and comfortable with the uses in those zoning districts. Adam, any follow-up on that?
Well, I mean, that, again, getting back to the whole purpose of the comprehensive plan, which then directs the zoning ordinance. So one falls in line with the other. And somebody comes before the commission seeking a change in the zone map or seeking some type of accommodation, again, you'll hear me say, and my advice to you will be to go back to look, the zoning ordinance lays out the classification, but then go back to look at the comprehensive plan, which really directs, and should direct a lot of these decisions, but more specifically, with regard to the facts that you've suggested, Rick, I mean, clearly if the use is unknown or they cannot provide some of that detail, but they're seeking some kind of a change in the classification or a special exception or special use, I think that needs to be taken into consideration by the Plan Commission. That lack of information certainly should have some bearing on your analysis of the application that's being presented.
Resident appears at a Plan Commission meeting and asks the Commission to consider creating an ordinance to restrict the speed limit on 93rd Avenue to 20 miles an hour. Can the Plan Commission create such an ordinance? Answer to that is no, that's a town council. That's not something that would appear in the zoning ordinance. You folks handle things that are in the zoning ordinance. And I should have said this a little earlier. When I refer to the zoning ordinance, it makes it sound like it's one ordinance, and it's a unified ordinance essentially. It's got our sign ordinance in there, our lighting ordinance, landscaping, gosh, what else,
Parking.
yeah, parking is in there. So it's a compilation of a number of ordinances, but they're combined into what we call the zoning ordinance. And this one happens to be ordinance 1483. As Paul knows, we're gonna be doing some revisions to this ordinance and the subdivision control ordinance this year. I've been looking forward to this for 3 years, so. We get a chance to make some changes to the document that, in my opinion, need to be made. But in any case, with a request for a speed limit change, that's not something the Plan Commission handles. That's a town council that would need to consider and adopt that. And so, not all ordinances begin with the Plan Commission. Only the subdivision control ordinance and those that are part of the zoning ordinance are what the Plan Commission hears and makes recommendation to the council on, but there are plenty of, we have, let's see, we just passed ordinance 1699. So we've got 1,700 ordinances in the history of this town, and most of those are outside of the zoning ordinance and subdivision control ordinance. So there's a lot of business the council takes up that isn't done at the Plan Commission level. Can the Plan Commission allow a development to vary from a requirement of the subdivision control ordinance? The answer to that is yes, it can. It's referred to as a waiver. And the waiver is supposed to be requested in writing by a developer at the public hearing stage for the primary plat. So if for some reason they don't want to put in a 60-foot wide street, they're asking you to go to 50-foot wide, you can grant that as a Plan Commission as a waiver as part of the primary plat approval. If they ask to put in no sidewalk, you can grant that as a waiver. You have the ability to grant waivers to the subdivision control ordinance. That's an important distinction, because the next question is, can you grant a variance from the requirement in the zoning ordinance? And the answer to that is no. That is the province of the BZA and in some cases, the town council. For those of you that are gonna be on the Board of Zoning Appeals, we're doing a training at the end of this month for you. And as John is familiar with, there are 2 of the 3 actions that the BZA takes that it makes recommendations only to the town council on. And Adam, as far as I know, it's only Lake and St. Joe counties in the state of Indiana where the Board of Zoning Appeals does not have exclusive jurisdiction over all the matters that it hears. Only those 2 counties. All the rest of Indiana, the Board of Zoning Appeals has authority over every matter that it hears, but not here and not St. Joe. In any case, this variance from the zoning ordinance is handled by the town council. Can the Plan Commission initiate a petition to rezone a property that it does not own? And that answer is yes. It does not need the permission of the landowner in order to rezone property. The Plan Commission can initiate such a petition, or the town council can instruct the Plan Commission to initiate such a petition. This is oftentimes done at the time of revising a comprehensive plan. It's very common for a municipality to change its zoning maps at the time that it changes its comprehensive plan, but it can be done outside of that process as well. Does the Plan Commission conduct public hearings on annexation matters? And that answer is no. The town council handles all annexation hearings. With that, I've reached the end. It's time for question and answer. That's a lot of information to digest. I have this obviously in this format, so I can email this to folks if you'd like to have that as a reference point. Paul knows that we've wanted to do Plan Commission training here for a couple, 2-3 years, and we're excited to be able to have this opportunity. We did the training with the BZA last year, and we're gonna repeat that again this year. And I would imagine that Adam and I will prepare future training sessions as well with updated information, because statutes, state law can change year to year and does. So there may be new and fresh information that we can bring to you folks on an annual basis, but it never hurts to have refresher information available and help guide us with what it is we do. So was that too much information, or are there any questions? Are you feeling like, why did I get on this board?
Questions or answers?
I just wanted to let everyone know that this has been live streaming, and so the video will be available, and you can access it through our website. Go to the YouTube channel, so you can review this anytime you would like to on the streaming video.
Thank you.
Right, right. I think the thing that I would really like to stress to you folks is that this is our town, so don't be afraid to ask the questions, and don't feel like you have to approve what comes before you. If it makes you uncomfortable, ask the questions of me, ask the questions of Adam, tap Paul's experience, and don't be afraid to ask the developer for clarifications of things. And the stronger you are, the stronger we are. I know John and Paul both particularly are very good about connectivity things, sidewalks, and there, you know, there might be something I miss when I'm looking at my plan review, and John and Paul, I don't think they ever miss the sidewalk connectivity issue, because that's important in our community. And I just want you to get comfortable with the fact that yes, there are some things that you'll have to approve because they meet our standards, but don't be afraid to ask the questions that you might have, because this is your community, and we're here to do the best we can, as several of us have said tonight, in moving forward with our community.
So with that, any questions or for Rick from the board? Before I turn it over to public comment? Well, before I turn it over to public comment, if you give me a minute or two to get on my soapbox. I've been on the board now, I think this will be my 5th year, and one of the best pieces of advice that I can give you is you're gonna get an agenda, and you just heard a lot of things today. You're gonna get an agenda. I would highly recommend you make time to sit with Rick. I was fortunate enough he would give me the time the first couple years I was on the board, and we would sit and we would go over each agenda items, and he would walk me through the book. And the great thing about Rick, he would give you the facts. He would not sort of persuade you on how to vote. He would say, here are the rules, regulation, here's what's before you. I would ask him questions, he would give me feedback. Never once was I swayed on how to vote. And I appreciate that, and I would recommend that to the board. What you heard today, we'll get more specific at each meeting. We got our next meeting next Wednesday, so there's items on the agenda. If you have time, sit with him, call him, ask the questions, he could walk you through. And was very helpful to me. Second thing, been on the board, we don't always have to agree. This board, I think, for the benefit of the town council, they need to hear different of opinions. John, Bob, Paul, we didn't agree all the time, and that's okay. One of the best things is we didn't agree, but after the meeting, we respected each other's opinion, and we moved on. Paul would tell you it's very hard, you know, when you sit up here, and the residents are very passionate about their community, and some of their comments could be a little hurtful, but we do the best we can. We got to feel comfortable with the decisions we make, and we move forward. Me and Paul disagree right now. I thought Paul should be on this board. I respect his opinion for not being on this board. He told me
second
what.
that.
I know, because
I
now I'm
second
sitting
that.
here, so, but we agree to disagree, but we're respectful. We are now considered somewhat leaders of the community. We need to be respectful to their issues that they're going to, But again, we gotta follow the rules and regulations of the zoning in front of us, and some that time that doesn't go in agreement with what they're feeling. So it's difficult. Take advantage of the leadership of Paul, with being on the board for so many years, and Rick, and their knowledge, and I would just try to absorb as much as possible from it. So, it's not gonna be easy, it will get easier, your knowledge will increase, so, we're just up here to do, we're up here to give difference of opinion, or the same opinion, to the town council so that they can make the best decision for the town. So, it's not always easy, it's not always the right one, they're not always gonna agree with you, but as long as you understand the facts in front of you and you feel comfortable, you know, we'll all do the right thing, so.
Well, 2 follow-up comments to that, if I could, John. One is I want to commend the council for making this a citizen board. In the past, it's had council members as part of the makeup, which it legitimately can do, but this council, Paul is sitting here, Brian Blazak, if you'd raise your hand, I think everybody knows, Wayne Pondinas is in the back there. 3 of our 5 council members, they decided that they wanted to, as much citizen involvement as they could muster on all of our boards and commissions, not just Plan Commission. But they decided that they were not, none of the council members were gonna sit on this board. They were gonna fill it with citizen members, and I applaud them for doing that. John also mentioned about he touched on the agendas, and my goal is to have the agenda out at least a week in advance of the given meeting, so everybody knows that. And to have it posted as well. So I send it to our Jason, our IT guy, and he puts it on the website. I send it to Beth. I don't know if Beth's not here any longer, but I send it to Beth, and she distributes it to folks that have asked for it. And then we post it on that door out there. So the goal is to do that a week ahead of time. Now, the law, I think, is just, I don't even know if specifically there was a law about posting the agenda. Meeting notice has to be given 48 hours ahead of the meeting time, and that's exclusive of holidays and weekends, correct?
I believe that's correct.
Yeah.
And I'm not aware of any legal requirement for posting the agenda.
Right, but as a practice, I try to get it out at least a week ahead of time to you folks and to get it out to the public in general, so they have advance notification of whatever it is that we're doing on the Plan Commission and the BZA. That's the only 2 agendas that I control, so thank you for letting me say that, John.
Okay.
I have one question.
No,
Sorry,
absolutely.
sorry.
No.
Rick, can you go over what is done at the study session? So since you don't actually pass out the agenda a week before the regular meeting, then that means that for the study session, you don't actually have what would be discussed.
No, I do that.
Oh, you
With the
do?
study session, I do
Okay.
that as well, Yolanda. I didn't mean to imply that I didn't. Every agenda, study session or regular meeting, I send those out a week ahead of time.
Okay. Is it the same topic? So would we expect the study session to be concerning the topics that we will essentially be voting on at the regular meeting?
Great question,
Yep.
yes. Typically,
Okay.
that is the case. You might find an item on the study session that isn't ready to go to the next regular meeting, so it might appear, it might even drop off the radar for a couple of months and then come back on. But typically, and I'm glad you asked that, typically, someone comes to a study session first and presents an idea. They go to the next regular Plan Commission meeting seeking permission to advertise for a public hearing in the following month. Now, permission to advertise is something we do as a it's not even a rule or regulation, it's a policy that we've sort of adopted. But as some of us have learned, you can't really deny a person, I said this earlier, you can't deny them the opportunity to come before you. So I don't know if we're gonna change that language. I know Paul and I have had a conversation about this. I don't know if we're gonna change that language as to what we call that. It shouldn't be permission to advertise, because that implies that you have the ability to tell that person no, that they cannot bring that request before you. But the reason it was implemented was to give staff more time to review a given development proposal. We didn't want somebody coming to a study session this month and then 2 weeks later coming to a public hearing on the matter. We want some time to get some information and digest the information before it comes to a public hearing. And to me, I think that's only fair to all of us to have more time. So I'm not sure exactly what we're going to do about that, but right now with our requirement of a 15-day notice, in most cases, you can't get from a study session to 2 weeks later, 14 days later, to a regular public meeting for a public hearing. There's not enough time. Sometimes there's 3 weeks between those dates, but usually it's just 2. But yes, you can expect that if we see it on the study session, some point in time, you're gonna see it on a regular meeting for some kind of discussion and approval, or action.
Yes,
If I may.
Absolutely.
Kind of add a little bit to the presentation. First of all, if I may approach, I got some homework for each of you, so this is just reading material. When Rick and I were talking about doing the training session, I decided to put together some information about some things and some terms and some terminology that you might commonly hear during meetings, including concrete standards, when we're talking about the subdivision control ordinance. And so what I've done is I've just put together some basic information about what concrete standards are and how they apply to the decision-making when reviewing a primary plat approval. And as I've indicated, the subdivision control ordinance must contain these standards by which the Plan Commission determines whether the plat qualifies for primary approval. And if the plat qualifies and meets those standards, then it is a ministerial act for the Plan Commission to approve that plat. And in other words, if they've met all of those standards, then the Plan Commission must approve the plat. And part of that stems from case law that's developed over the course of really the last 30 to 40 years that interprets the Indiana code that provides for the creation of the subdivision control ordinance. And I've provided a couple of cases in the materials, and specifically the second of the 2 cases, which is the Brandt versus Custom Design Constructors Corp case, is a pretty good starting point for each of you to review how courts would review decisions made by the Plan Commission. And this is specifically a Court of Appeals opinion, which means that it had first gone to a trial court, and then it has been taken up to the Court of Appeals, and the Court of Appeals has rendered an opinion. This is a copy of that opinion. And I think just in his example for the Brandt case, the facts of that case were that Blake and Janet Wallace own a tract of real estate containing approximately 321 acres in Boone County. The real estate is primarily unimproved timberland and farmland and contains a 32-acre lake. The Wallaces entered into a contract with Custom Design to develop the real estate into a residential subdivision known as Pennsbury, which would contain approximately 250 single-family dwelling lots and common areas. So as you can see, the facts of this case very similar to towns across Indiana over the course of the last 30, 40 years. The developer filed its application for approval of primary plat for Pennsbury with the commission. And at that time, the 6-person commission was vested with exclusive authority to receive, consider, and approve or disapprove applications for residential subdivisions in Boone County, much as this Plan Commission has that jurisdictional authority for applications in the town of St. John. As part of the application, the developer requested the commission to grant a variance in the maximum distance by which a cul-de-sac street could extend beyond the last intersecting street. After a number of meetings and considerations, the commission was split, and essentially were deadlocked. And then the developer filed was then called a writ of certiorari. That's a process that's no longer employed by the courts to review decisions made by the Plan Commission. That's been since updated, and it's no longer referred to that. But in this case, the court reviewed all of the facts, reviewed the petition, reviewed the subdivision control ordinance, and basically determined that the concrete standards, which the purpose of which is to provide fair warning and protection to both the landowners and developers as to what the Plan Commission will consider for purposes of the plat approval. And the court states that if after a hearing, the Plan Commission determines that the application and plat comply with the standards in the subdivision control ordinance, then it shall make written findings and a decision granting primary approval to the plat. The approval of a plat that meets the requirements of the applicable ordinance constitutes a ministerial act as opposed to a discretionary act. And again, ministerial meaning that there is no discretion on the part of the Plan Commission to deny that application if it meets all of those concrete standards. And so the court held that, in other words, if the proposed plat meets the concrete standards of the subdivision control ordinance, then the approval or disapproval of the plat on the basis of the controlling standards is ministerial. So in this particular case, the court went on to consider and review what parts of the ordinance could be considered concrete standards as opposed to merely objectives for the Plan Commission. And I think, again, without going into a lot of detail, this opinion allows you to read how the court interpreted the ordinance and determined what was a concrete standard and what isn't a concrete standard. So that's, I wanted to provide that. This is reading material. Again, if you have any questions about the opinion itself, I'd be happy to talk further with you about that. Also, I've included some material that Rick has covered regarding the process for subdivision plat approval. I've taken some of these provisions directly from the Indiana Code, and you'll see on the page there are footnotes to the specific code sections where that is found. And so with that, I wanted to touch on, just to conclude, a couple of things that Rick had mentioned earlier. First of all, the question about the circumstance where the Plan Commission would not make any recommendation to the legislative body, which is the town council, and the town council fails to act within the 90 days. I confirmed my earlier statement that if the legislative body fails to act within the 90 days, it is defeated. So whatever proposal, received no recommendation from this body and then goes to the town council and they fail to act, that proposal would be defeated. The role of the legislative body, which is the town council, Rick touched on this a little bit earlier, but it's really a variable role in the sense that as far as subdivision plat approval and development plan approvals, which are not necessarily relevant to the conversation, the legislative body, i.e. the town council, plays no role in the decision reached by the Plan Commission on those matters. So that's exclusively the jurisdiction of the Plan Commission. For other matters, such as amendments to the zoning ordinance, rezoning petitions, that's why this is called an advisory Plan Commission, because it will hear the evidence at the hearing, that's the function of the Plan Commission, and then basically make a recommendation or render advice to the legislative body, the town council, who ultimately will make the decision on those requests to the town. So I'd like to consider it a variable relationship that you have with the legislative body in that sense. Some things you have exclusive control over and make the final decision. Other things will be recommendations made to the town council. One thing Rick touched on about ex parte communications, he's correct. You know, as plan commission members, there's no specific statutory prohibition, but my advice to you as members is that you should avoid ex parte communications whenever you can do so. I mean, there may be people that will want to grab you by the ear and say something either for or against any proposal that you're considering. And my advice to you is to simply avoid that. Should be left for the public meetings and for the public hearings. And you have to do your best to try to avoid that type of conversation or any type of discussion that somebody may want to have with you regarding an item that will come before the Plan Commission as a whole. Conflict of interest. If any of you would ever have some type of an interest, and the code defines it as a direct or indirect financial interest, and that seems unlikely, but each of you have professional jobs, and you may be working for a company, or may have had your employment may be related to some company. If you think there's a conflict of interest, you should disclose that, because ultimately the Plan Commission might consider that, and it would be good to discuss whether that conflict of interest might prevent you from taking any action on any given matter that's before the Plan Commission. So if there's a question about whether any direct or indirect financial interest before anything that would come before the Plan Commission, I think the prudent thing to do is to discuss that amongst yourselves, or you can discuss that with me, to get a little bit more insight or input about whether that in fact would be a conflict that might prevent you from participating in any discussion or decisions that would be made. And I think Rick, you did an excellent job of touching a lot of the bases that will be presented in future meetings with the Plan Commission.
Thank you.
Thank you for doing so.
Okay, I'm gonna bring it back to the board. Is there anything else? Paul?
Mr. Chairman, if you don't mind, I'd like to add a few comments of my own. I've made a few notes. So first, I'll start with what Adam left off with and the ex parte communication factor. So I explored this in great detail over the past few years because it was my desire to communicate in the best way possible with residents and inform them on what's going on. So, and Adam, you could stop me and correct me if I'm wrong on this, but what I've taken up as a policy to stay out of trouble yet provide information is simply that. I'd be happy to provide information. I've done so online, in person, at the grocery store. If somebody says, hey, what's going on? I think there's a test I kind of go through. Is this public knowledge? Is it listed on an agenda? Is it available out there? Okay, it is. Well, I could tell people, yeah, sure, there's a filling station proposed at 231 and 41, and here's what they're proposing. But beyond that, I wouldn't discuss or have any dialogue or decision-making, but it's okay to share information that's already public knowledge. Or if somebody approaches you after a meeting, and it would be okay to repeat what occurred at that meeting because they can go online and find it anyway. So it's okay to share that information and keep people informed, especially if they missed it or if they had a particular interest in anything. So I would encourage you to do the sharing of already public information. So you don't have to completely clam up and never say anything. There's no secrets if it's already public. Beyond that, just a few more things. Some of you have been here for a while or been here previously. Bob and John Gill, you guys have been on this Plan Commission before. John, you've been here a while. Yolanda, you're new. Donna and Nancy, you're all new to this. So it's confusing. There's a lot to digest. For sure, use Rick as a resource. He's really an asset to the town. He's been doing this for decades, and he'd be happy to sit down and have a cup of coffee with you and sort any agenda items out in a matter of minutes. And Rick will also prepare a summary, which is really nice. So when you come to the meeting, not only will there be agenda, but he'll usually have a summary for each petitioner, kind of giving you the ins and outs, a little bit of guidance. So that'll be helpful too. So But I'd like to say this as far as just adding to the training. This body, there's a lot of little things you do, but primarily there's two things you do, and they seem the same, but they're very different. They seem the same when you're new, okay? One is rezoning. You'll hear that a lot. So rezoning is when we take a piece of land that could be used for one use and allow it to be changed to another use. That is a very significant impact on the town, significant. And it's a decision that you're making that recommendation to the town council. So as Rick mentioned, it could be residential and they want to go commercial, vice versa. So that one is a decision that you will use the Indiana statute considerations to make. So that is more falls on your lap to make that judgment using those considerations. So the other thing you do, which is entirely different, is the plat approval you keep hearing about. Now, plat approval so you can already assume that the land is already zoned a certain way. That's already done, the rezoning or whatever it is. They bring in a piece of land and say, well, it's already R1 and we want to build houses, right? So they lay out the streets and the sidewalks and you kind of help guide all that, look for any errors or mistakes. As does our engineer and Rick, they do the stormwater calculations, everything's done. So that's when it gets to be more of a ministerial act. However, I would advise and caution you to go through it carefully. We want to make sure we're enforcing our ordinances. As great as Rick is and Ken Kraus at doing their job, I want to do the homework myself because I'm the one voting on it when I'm sitting up there. Rick doesn't vote on it, you do. So really, as a plan commission member, I always felt it my responsibility to go through and triple check all the work and make sure that sidewalks are where they're supposed to be and that everything's, considered, and has a traffic study been done? And I want to see the traffic study and what's recommended. I mean, all those little steps. We could be a better plan commission if we always take all those steps and make sure they're all done. Because the developer, of course, they're business people and they're going to come up here and say, hey, everything's fine, it's great, and so it's our job to, as a town to make sure that it is in fact what it's supposed to be and everything's as it should be. So you have two documents there that you'll primarily use. The big thick book is our zoning ordinance, and that book is like a rule book. So it's pretty simple. If it's residential 1, like R1, there's a set of rules for R1. If it's R2, there's a set of rules for R2, and that dictates that. Then when you get down to plat approval, you have that smaller book, that's subdivision control, and that has more detailed things like the width of streets or sidewalks, things like that. So again, Rick and the engineer go through all that for the most part. It's just your job to double check those. So you'll have your plat approvals, you'll have your rezonings. They're kind of apples and oranges, and we'll help you understand that best we can. My phone line's always open as well. The enforcement of the ordinance, we want to avoid waivers at all possible. At least that's been my operating mode. I want a sidewalk even if there's nothing but farm fields around, because someday there'll be something next to it. So a typical waiver request is, well, we don't want to put a sidewalk in because it doesn't go anywhere. Well, it's going to go somewhere. This is growing at quite a pace. So we've become more consistent with waivers and enforcing ordinance. And in fact, developers tend to like it, and I've had them communicate that to me. It's better. We really don't care what you guys want. Just if you're going to do it by the book, just do it by the book so we know what to expect. We can calculate that in. We can come in and be ready to go. So consistency is good. Enforcement in a consistent manner is good. It actually helps our developers know what they need to do when they come in front of us. So again, my phone's always open. If anybody needs anything, call me, call Rick. Adam can help too. Or one of the more tenured members here would be happy to help you out. So appreciate it. Thank you.
With that, if there's no more comments from the board, I'm going to open up to public comment. I know no one signed up, but I will still open it up to public comment. Going once, going twice. All right, with that, any comments from the board? If not, we'll call for adjournment.
Looking for a motion? Motion
Do
to
we need a
adjourn?
motion?
It's not required.
Well, I'll call for a motion. Motion to adjourn. Do I have a second?
Second.